Good morning, folks. Thanks, Garth. I think we're all profoundly saddened by what happened in Queensland and Victoria, Christchurch and now Japan. And I think what it does is demonstrate what a fragile grasp we all have on life. I have to say that I'm not a conference person, but there is one conference for many years that I come to every year, and it's this one. And there's a reason for that, and that is that I find these conferences to be enlightening, uplifting, and I find this to be an industry which is extraordinarily generous in spirit. And I think that if there's any year where the conference needs to reflect those themes of enlightenment, uplift, and generosity, it's this one. Now, I can't promise you that my presentation will necessarily be uplifting, but I do hope that it will at least be somewhat enlightening. Thanks to Matt and the folks at Graphic Cafe for sponsoring it. This section, this part of the presentation is really divided into two parts. I wanted to give you a quick heads up on some law reform initiatives in New Zealand, and then I wanted to give you some recent decisions on misleading conduct that I think are particularly relevant to the folks in the direct selling industry. Now, if any of you want a copy of the slides, then just give me at the end your business card with the word slides on the back, and I'll have them emailed to you, no problem. Dealing first with consumer law reform, and Garth mentioned this earlier. I just want to go into this in a little bit more detail. It's an issue about which I feel very strongly. The Ministry of Consumer Affairs is currently proposing some reforms to our consumer laws, which I describe as a little bit like the Australian consumer law light. It's released a discussion paper and then several additional discussion papers which set out proposals for reform. And the laws being considered for reform are, broadly speaking, the Fair Trading Act and the Consumer Guarantees Act, which is our consumer protection legislation. Now, there were 4 proposed reforms. They haven't been announced yet, but we're pretty certain that they'll come through. 4 proposed reforms that I think are particularly relevant for you. First, there's a proposed prohibition on unfair contract terms, and the reform is aimed at standard form contracts with consumers, so therefore relevant to things like distribution contracts. But it may also extend, and we don't know whether it will or not, to standard form contracts with other businesses. Effectively, what a prohibition on unfair contracts will mean is that aspects of your standard form contracts may be unenforceable. There's also a proposal for prohibition on unconscionable conduct, and that's aimed at preventing businesses from putting pressure on consumers and small businesses. What that might mean is that high pressure sales tactics may in future be regarded in New Zealand as unconscionable and unenforceable. There's a proposed prohibition on unsubstantiated claims, and this means that you could be required to prove any claim made if you're issued a substantiation notice by the Commerce Commission, which, when you think about it, substantially and completely reverses the onus of proof. The Commerce Commission now doesn't have to prove anything, you've got to prove it to them. And finally, it's proposed that we adopt the insane Australian idea of court enforceable undertakings, which is effectively an agreement between the Commission and a person who admits to breaching an act. And the idea is that if they don't comply with the court enforceable undertaking, then they can be prosecuted. If this Australian approach would be adopted in New Zealand, it's going to allow the Commerce Commission to be even more aggressive in enforcing the Fair Trading Act, because undertakings are far cheaper than prosecutions. And what we've observed in Australia is that the ACCC will wander around with court enforceable undertakings, bullying other members of the industry into believing that those court enforceable undertakings represent a statement of the law. They are nothing of the type. They have nothing of that sort. Oftentimes what you'll see, and I've acted for a large number of companies who have cut deals with the Commerce Commission in New Zealand, often they represent just a pragmatic approach in terms of compromising a claim simply to get rid of it. So we've got some general concerns with the proposed reforms, and my view is there's absolutely no need for the reform. I think the reforms are inconsistent with government policy. In fact, I'd invite you to read the quote on the left-hand side of the slide, which is deeply ironic, considering the Minister for Regulatory Reform, the leader of the party ACT, which effectively regards itself as a liberal centre-right party, and the Minister of Consumer Affairs is in fact a member of the same party. I was so concerned about this act that on my own bat I went to Wellington and met with the Minister and asked him how he could justify being in a party where he was effectively going to introduce 31 new laws. He didn't seem to have an answer for that. So Simpson Grierson, as I say, feels very strongly about this. We've published a number of newsletters on both the general and the specific problems with consumer law reform. I'm absolutely committed to doing everything I personally can to stop these reforms. I think they're completely unnecessary. If you would like to find out more about these general and specific problems that we certainly have with the reforms, then again give me a business card at the end of the session with CLR written on the back, and I'll arrange to have them sent to you free of charge. Last year I spoke to you about the regulation of dietary supplements, and I covered the introduction in New Zealand of the Supplemented Food Standard and the proposed Natural and Traditional Health Products Bill. Today what I want to do is just briefly cover how dietary supplements are currently regulated and the progress, or more importantly the lack of progress, on the proposed Natural Health Products Bill. Now, all dietary supplements used to be regulated under the New Zealand Dietary Supplement Regulations, but in March last year the Supplemented Food Standard came into force, which significantly alters how dietary supplements are regulated. And what I've got up there for you is a diagram which broadly defines how it works. The Supplemented Food Standard resulted in dietary supplements being split into two categories. You've got food-type dietary supplements and therapeutic-type dietary supplements. And food-type dietary supplements are regulated as supplemented foods by the Supplemented Food Standard. And examples of food-type dietary supplements include sports foods and sports powders with added vitamins and minerals and other substances higher than might be permitted in the Food Standards Code. And therapeutic dietary supplements continue to be regulated by the Dietary Supplements Regulations. Last year, a Natural and Traditional Health Products Bill was proposed to replace the Dietary Supplement Regulations and the Supplemented Food Standard, but that seems to have stalled. Garth, you'd agree with that? And we have no idea where that is heading. So we're in a crazy transitional no man's land at the moment, where mechanisms were put in place effectively to tide us over against a setting where, in my view, there's absolutely nothing wrong with the previous law in the first place. It gets worse. The Food Bill. Parliament is currently considering a bill to replace the Food Act, and there are a number of really good things about the Food Act. I'm the legal counsel for the New Zealand Food and Grocery Council, which represents a very, very high proportion of food and grocery producers in New Zealand. This bill is one of the most important issues which is confronting the food industry, and the FGC and ourselves have got a number of concerns with the bill. The first is that the bill specified that all food produced in New Zealand has got to comply with the New Zealand food regulations, for example, labelling. But what's proposed, which is crazy, is that compliance is required even if the products had been produced solely for the purpose of export. So you think about that. They're going to require compliance with New Zealand law against a setting where the goods are going to be exported somewhere else. There's a great example that the FGC has given in relation to beer, where the standards and labelling requirements between New Zealand and the UK are completely different. So if you comply with this legislation, you'll in fact not be in compliance with the country to which you're exporting the products. And of course, the bureaucrats have an answer for this, which is that you go and get an exemption. We all know that anyone who's ever dealt with exemptions in bureaucracy knows that it's slow, expensive and time-consuming. It won't surprise you to know that we've published a newsletter on this issue as well. And if you are in the food industry and you want to know more, again, give me a business card with the words Food Bill on the back, and I'll again have one sent to you free of charge.